Ever wondered why your job comes with its own special rulebook? It seems like a simple question, right? But it's a question that has shaped our world for more than 100 years. Today, we're going to get into the real purpose of labor law. I mean, think about it. We use contract law for pretty much everything, from buying a cup of coffee to massive corporate mergers. So why is a job contract treated so differently? What's the big deal? Well, as we're about to find out, a job is so much more than just words on a page. So here's how we're going to break it all down. First up, we'll see why standard contract law just isn't up to the task when it comes to employment. Then we'll look at the big ideas, the constitutional principles that are the bedrock of labor law. After that, we'll get down to brass tacks. Who and what do these laws actually cover? And finally, we'll tackle the elephant in the room, the modern world of informal and gig work. All right, so let's start at the very beginning. The entire field of labor law really exists for one reason. A job is a unique kind of relationship, and a standard contract just can't handle its complexities. It all boils down to this one core idea: inequality of bargaining power. You see, contract law kind of imagines two equal parties freely coming to a perfect agreement. But is that realistic when you're looking for a job? Almost never. The employer holds most of the cards. So the very first job of labor law is to step in and try to balance those scales a little. And this quote really gets to the human heart of it all. A job isn't like selling a car or a bag of flour. It's about a person's life, their dignity. Work gives us meaning. It connects us to a community. So labor law has this really tricky job of trying to make the market work while also making sure people aren't treated like just another item to be bought and sold. So what really makes a job contract so special? Well, for one, it's about control. The employer tells the employee what to do. The contracts are also intentionally vague, to allow for flexibility, which means we need some default rules. And since it's a long-term relationship, you can't just run to court over every little thing. You need a different kind of system to handle disputes. Okay, so if standard contracts just don't cut it, what's the alternative? The answer is built on a foundation of really big legal ideas. And in India, this comes down to the Constitution and some very different views on what labor law is even for. For the longest time, people thought about labor laws as a kind of necessary evil. Sure, they protected people, but they were seen as a drag on the economy. But that thinking is totally flipped. The new narrative says that, actually, good labor laws can help the market. They can fix problems, reduce costs, and even make everyone more productive. It's a shift from seeing regulation as a bug to seeing it as a feature. And here in India, the ultimate purpose of labor law is baked right into the Constitution. It's not just about sorting out workplace arguments. It's about building a more equal society. That vision is the North Star for how every single labor law is supposed to be understood. Take Article 23, for example. On the surface, it seems pretty straightforward, a ban on slavery and trafficking. But Indian courts have found a much deeper meaning in these words. This is where things get really powerful. In the famous Asian Games case, the Supreme Court said, wait a minute, paying someone less than the minimum wage, that's a form of forced labor. Why? Because nobody would choose to work for less than they need to survive, unless their economic situation was forcing them to. And just like that, a simple paycheck became connected to a fundamental human right. It's the same kind of big picture thinking with Article 21, the right to life. The courts have said this isn't just about breathing. It's about the right to earn a livelihood, and the right to do so in a safe place. The Constitution isn't some dusty old document. It's alive, and it sets the bar for what decent work should look like. Okay, so we have the why and the big guiding principles. But for any of this to matter in the real world, the law has to answer two very practical questions. Where do these laws apply, and who exactly do they protect? This first question, what even is an industry, might sound a bit academic, but trust me, the answer has huge, real-world consequences. Because if your workplace doesn't legally count as an industry, then a lot of these protections we're talking about might not apply to you at all. The big answer came from this landmark case, Bangalore Water Supply, which gave us the famous triple test. It's basically a three-part checklist. Is there an organized, systematic activity? Do employers and employees work together? And is it all for making or distributing goods or services? If you can say yes to all three, then it doesn't matter if it's a factory, a hospital, or a school, it's probably an industry in the eyes of the law. There is, however, one major exception. The core functions of the government, things only the state can do, like running the courts, the police force, or the army, those are carved out. They are not considered industries. Now, for that second huge question, who is a worker? The law draws this massive line in the sand.
On one side, you have an employee, someone in a contract of service. On the other, you have an independent contractor, in a contract for service. And this distinction is everything, because most labor laws are built to protect employees, not contractors.
So how do courts tell the difference? The old way was super simple, the control test. Basically, does the boss tell you how to do your job? But that's too rigid for today's world. So now courts use a much broader multi-factor test. They look at the whole picture. Who owns the equipment? Who takes the financial risk? It's all about looking past the labels to see what the relationship really is.
And all of this brings us right up to today, to the single biggest challenge for labor law in the 21st century. How do these old ideas hold up in our modern economy?
Well, the scale of the challenge is just staggering. In India, an estimated 91% of the workforce is in the informal sector. That means for the vast, vast majority of people, that whole legal safety net we just talked about, it doesn't even reach them.
So why? How do you get a gap that big? Well, part of it is actually built into the law. Lots of laws only kick in when a company has 10 or 20 or more employees. But the reality is that 94% of workplaces in India have fewer than 5 people. Add in things like outsourcing and a narrow focus on employment, and millions of people just fall through the cracks. And of course, the gig economy has put these old definitions under a global microscope. Everyone is grappling with this. You see places like California trying an ABC test that assumes someone is an employee. The UK created a third middle category of worker. The EU is trying to create a presumption of employment. There are no easy answers, but everyone is wrestling with it. And that leaves us right back where we started, but with a modern twist. Labor law was created to deal with the power of a human boss. But what happens when your boss is an algorithm, when control comes from an app on your phone? It forces us to ask that fundamental question all over again. What does it mean to be a worker today? And what kind of protection do we need to make sure that work is still a source of dignity for everyone?